Bismillahirrahmanirrahim. In the name of Allah, the Compassionate and the Merciful. I am Advocate Zaheer Hassan. I practice in Rawalpindi and Islamabad, the twin cities of Pakistan. I primarily practice on civil, criminal and the constitutional side. During the self-exiled days of quarantine, I conceived the idea of having a bilateral relation to be established with the legal fraternity using the social media. Consequently, I have got my own YouTube channel with a view to promote the legal education, the law, and to have a bilateral relation of learning with the lawyers, with the legal fraternity in Pakistan and outside Pakistan. So my YouTube channel is beneficial for the students of law who have yet to qualify for their exam. My YouTube channel is equally good for the lawyers who would like to practice both on the criminal and the civil side. My YouTube channel is beneficial for everybody who would like to know about law and have a keen interest in this subject. I have chosen multiple topics to be discussed here on this YouTube channel. But the topic today I have chosen is concerning the substantive law, that is Code of Criminal Procedure. I am going to discuss with you the criminal trial in the light of provisions of Code of Criminal Procedure. The importance of substantive law was described by Syed in one of his very famous quotations. He says, "Magistrate governs the people. Law governs the magistrate. Magistrate is a living law. Law is a silent magistrate." And over here, law means substantive law and the law as enunciated by the superior courts as well. So let's begin our first session. There is a crude definition of trial because the subject today is the criminal trial under the provision of Code of Criminal Procedure. There is a definition of criminal trial, and that is criminal trial is a formal examination of evidence by the learned court to hold accused either guilty or acquit him. This is a very crude definition. We will go by this definition and try to explain everything. When we say the judge examines evidence to hold an individual guilty or otherwise, we mean evidence collected by the police. And when evidence is collected by the police, definitely some delinquent individual in the society commits an offense. Mr. ABCD has committed an offense of burglary, dacoity, rape, murder, theft, whatever. And that occurrence is reported to the local police, who under section 154 of Code of Criminal Procedure lodges an FIR. FIR is abbreviation of First Information Report. The salient features of FIR are that it contains the name of the complainant or informant, its date of registration or lodging of FIR, the substance of allegation or the story narrated by the informant, that what he saw, what happened, what was the state of affairs he brought into the notice of the police. The police reduces it into writing. FIR has a formal format, and very shortly I'll show you that this is the format. And here we are, this is the format of FIR. You can download this format available on the net as well. After the FIR is formally lodged, police triggers this investigation. Police definitely goes at the spot and tries to take into possession of anything which is lying over there. Say, we'll just for today, we'll take an instance, it's a murder case, say. So police goes at the spot and there's a dead body lying there, there's a blood oozing out of dead body, there are crime empties, say he was, deceased was shot at using the 30-bore pistol, and the crime empties of the pistol are also lying there. And there are certain other things which are also lying there. The police collects everything in terms of evidence and also records the oral evidence there, and also prepares the site map or inspection notes, whatever, and say next day or the same day apprehends and arrests the accused as well, and he is interrogated, he is exposed to the remand, physical remand for 14 days, and thereafter he is sent to the judicial remand. We will discuss in a different session the concept of remand and its outer limit, whatever its features. But taking an accused into the police custody for the purpose of interrogation is called remand. It is, the outer limit is 14 days, and when that remand is over, he is sent to the jail, which is called the judicial remand, right? So accused has been apprehended, police has completed investigation. Now what's next? Whatever police has collected in terms of evidence has to be compiled in a prescribed form, right? And that prescribed form is defined under section 173 of Code of Criminal Procedure. It is called the inquest report in the legal parlance, but in a local parlance it is called challan. The word challan is never used in the Code of Criminal Procedure, but it is commonly known in the subordinate word for 173 report under section 173 Code of Criminal Procedure. Here is, I would like to show you an image of challan. Here is the image of challan, kindly see. If you peruse challan, you will see it has 7 columns, and what these columns suggest? Column number 1 reflects the name of the complainant or the informant, Mr. ABCD. Column number 2 reflects the name of declared innocent person by the police or against whom no evidence so far has been forthcoming, or also the names of those accused persons who have been running from the law, are fugitive from law, in local language called ishtihari. Ishtihari mulzaman, their name will reflect in column number 2. Column number 3 reflects the accused person against whom so far the cogent, credible evidence has been collected by the police and they have been challaned, meaning thereby they'll now face the trial. They might be convicted, whatever. Column number 4 reflects the names of those accused persons whom the bail has been granted, or those who are on bail, are not arrested, or were arrested, were granted the bail, but are not in the jail. Column number 5 contains the the column number 5 contains the detail of the case property which was either used in the commission of offense, whatever. And column number 6 reflects the name of PWs, the prosecution witnesses, their names, addresses, their father name, whatever. And column number 7 reflects the factual resume, the detail of this criminal case, which I said was a murder case, say all the detail, the motive, the name of parties, how occurrence took place, who participated in it, who was arrested, how recoveries were affected, what was the nature of recovery. And at the end, it also contains column number 7, the ipsi dixi of the police, the opinion of the police, qua the guilt or innocence of some of the accused or all of the accused persons that they are guilty. So this is the challan under section 173, which is prepared by the investigating officer, and then it is tendered and submitted in the office of the district attorney. The district attorney office receives it, scrutinizes it. The law officers over there see as to whether it has certain defects or lacunas left. If there are, they are referred back to the investigating officer and say if it is fit, and they see there's a possibility of conviction of accused, successfully the guilt can be brought home, then the same is submitted to the court of Ilaka magistrate. In our legal system, every police station has got a magistrate over it, superintending all its activities. In his court, the matter is submitted. Here, a very important question will be raised regarding the jurisdiction, here. If the learned magistrate considers that this case can be tried by him, he is empowered under the law to try this offense, then he will keep this matter with him and he will proceed with the trial. And if he finds this matter cannot be adjudicated by him as a trial magistrate, as trial court, he will refer it to the learned sessions court, and learned session court will keep this matter with it or will entrust to any additional sessions judge in the district. And again I say here the question of jurisdiction starts here. It means that magistrates are invested with certain powers. In order to understand the powers of the magistrate, I would like to invite your very kind attention to section 6 of Code of Criminal Procedure, schedule 3 of the Code of Criminal Procedure, and section 30 and 36 of Code of Criminal Procedure. You will see the powers of magistrate. There are 3 classes. Section 6 defines there are 2 classes of criminal courts in Pakistan. Number 1, the Court of Session. Number 2, the Court of Magistrate. And Court of Magistrate is further bifurcated and stratified into 3 classes: the first, second, and the third class. And their powers, if you would like to know in detail, schedule 3 of Code of Criminal Procedure may kindly be perused. Another kind of jurisdiction which is discussed in Code of Criminal Procedure is discussed in chapter 15 of Code of Criminal Procedure. Section 177 to 188 discuss the territorial jurisdiction of the courts, who can adjudicate the matter, who can take the cognizance. I will have a separate session on this topic. This is very important topic, but just you go through section 177 to 188 and you will see that how jurisdiction can be assumed in terms of taking cognizance by the learned judges. The different situations have been discussed over here. We cannot even have a bird's eye view because it's a detailed subject. Now we move forward. Let's say learned sessions judge has taken the cognizance of the matter and the trial has just started, right? What is the first step? The first of all, accused will be handed over free of cost the copies of evidence, the bundle of evidence against him, free of cost. This activity happens under section 265C of Code of Criminal Procedure. Inspection notes, FIR, statements in section 161 or 164. Every material which is against the accused person will be given to him, and if I recall, this is challan under section 173, stricto sensu, that copies of challan etc. will be given to him so that he could defend himself. This is the practical manifestation of a rule of odi ultum patrum, that nobody should be condemned unheard. So he is equipped with the material against him. Thereafter what happens? Court under section 25D of Code of Criminal Procedure, before framing of charge, would see as to whether sufficient material available to proceed with the trial and there is any possibility of conviction of accused. If it is affirmative, then the learned judge would frame the charge under section 265D of Code of Criminal Procedure. Here it is noteworthy that charge is independently elaborated and defined in section 221 and onwards of Code of Criminal Procedure, whereas the charge is framed for the Sessions Court under section 265D of Code of Criminal Procedure, and as far as magistrate is concerned under section 242 of Code of Criminal Procedure. The 2 distinct sections of law deal for framing of charges for 2 different courts. What is defined in the section 221? 221 221 section Criminal Procedure Code defines the charge to specifically explain and elaborate the offense committed, if name of any offense, right? The manner in which it was committed, and every detail which is important to equip the accused with, with this set of allegation against him contained in FIR and investigation. And if he is previously convicted and prosecution wants enhanced sentence, then it will be also mentioned in the challan as well. Well, if accused pleads guilty, court has got discretion to convict him, and if he says not guilty, then learned court will proceed with the trial, and prosecution evidence shall be summoned under section 265F of Code of Criminal Procedure. 265F of Code of Criminal Procedure contains 7 subsections. The first 3 sections discuss the summoning and requisition of the prosecution evidence and the witnesses, right? Rest of the sections 4, 5, 6, 7 discuss the evidence of the accused. Yani accused is also equipped, is bestowed upon with the opportunity to prove himself not guilty by calling defense witnesses, or he himself could be as good a defense witness for himself. And even if accused person desires the court to issue its process to summon the requisition the presence of any accused, any witness, he even can file an application, and the court is obliged to requisition the presence of a witness testifying in favor of the accused person. He could be anybody, right? So section 265F elaborates that evidence of prosecution will be summoned, and if accused so desires, his evidence will also be summoned. When accused is offered by the court to adduce evidence, this is actually the fag end of the trial. Here the trial is almost concluded as far as prosecution evidence is concerned. There are 2 sections of law which come into play, section 340 of CRPC or 342 of CRPC. If the accused himself would like to be examined on oath, and he will be definitely subject to cross-examination as well, then he opts to be examined under section 340 of CRPC. So 340 of CRPC comes into play when accused would like to be examined on oath, right? And then there's another situation when the accused says, no, I would not like to be examined on oath. However, he gives a reply to certain queries in the question 8, 7, 9, 10, 20 questions, whatever the court formulates. And the accused is to answer these questions. Definitely these questions are answered by the pleaders, but anyhow, it's our practice that these questions are formulated. And every evidence which has been so far brought on the record will be put into an apple pie order and will be converted in these questions, and accused will reply all these questions. And when this questionnaire is over, reply has been given, the evidence of both sides is cut and dried for the prosecution and for the defense, right? I would like to here mention Article 132 of Qanun-e-Shahadat. Article 132 of Qanun-e-Shahadat, or law of evidence, discusses the examination in chief, cross-examination and re-examination. I would like to have a separate session on this subject: cross-examination, examination in chief and re-examination, and the Criminal Procedure Codes provision section 540 of CRPC in that context, and other provisions which are very important for summoning, re-summoning, examining, re-examining. We have to discuss all that at separate session. So the next section of law which governs the next proceeding is section 265G of Code of Criminal Procedure, which says prosecution is to sum up the case. This section of law discusses if evidence has been led by the accused person in his defense on oath, then case is to be opened in terms of final arguments by his counsel or by him. Otherwise, in all cases, this is the prosecution to sum up the cases. No. When the case is summed up, arguments have been heard, court under section 265H of Code of Criminal Procedure would either acquit the accused or convict the accused. Well, since it was a murder case, we discussed, we'll see what happens next. When, if accused is acquitted, then he is forthwith allowed to enjoy the fruits of liberty. If he was on bail, his surety is discharged, and if there was some case property which was held by the court and belonged to him, the same is the destiny of that property will be decided as well in that verdict. He can claim that property in certain eventualities. And if, God forbid, he is convicted and he was on bail, he will be taken into custody and he will be sent to the jail with a warrant to commit him in the jail to serve out his sentence. Warrant of commitment will be issued to the jail superintendent. And in death sentence case, warrant of commitment of accused under section 374 will be served on the jail superintendent, and at the same time the murder reference shall be prepared under section 374 of Code of Criminal Procedure. The legislature has devised this plan that instead of implementing or executing the order of the Sessions Court, the accused destiny shall further need certification from the High Court. So 2 judges of the High Court forming a divisional bench. Before them, the murder reference will be sent under section 374 of CRPC. That bench will scrutinize the material, and if finds that further inquiry should take place, then remand the matter. And in certain eventualities, it still happens under section 376 of CRPC, the death sentence could be confirmed or could be annulled, either way. Well, say if death sentence has been confirmed and no appeal has been preferred before the Honorable Supreme Court, what will happen? The black warrants will be issued, or the death warrants will be issued by the Sessions Court in the name of the jail superintendent under section 381 of CRPC to execute the sentence, hang the accused by neck bone until he is dead, and return the warrant, death warrant or the black warrants, back to the Sessions Court, certifying the fact that execution has taken place. Well, this was the death sentence. Say there were 3 people, one was sentenced to death, 2 were sentenced to be behind the bars for say 10 years. And say the offense of 302 also had the offense of 376, 380 or other offenses were committed simultaneously in that occurrence. And these 2 individuals who were given the 10 years imprisonment were also charged for all these offenses as well, other offenses as well. Then the sentence either could run concurrently or consecutively. I would like to have a separate session to discuss this aspect of our legal system, running sentences concurrently or running sentences consecutively. The superior courts have usually patronized the concept of running sentences concurrently, but we'll discuss it in a separate session. Then section 382B also comes into play for the fate of these accused persons. If they were arrested, these 2 accused persons, say there were 3, 1 was convicted, 2 are spending their time behind the bars in terms of a sentence. They were imprisoned for 10 years. Then if they were arrested, in this case they have spent some time behind the bar, or say their bail was never granted and it has taken 2 years to conclude the trial, then these 2 years will be adjusted into their sentence of 10 years. This operation happens in section 382B of the Code of Criminal Procedure. And if accused, complainant or the prosecution is not satisfied with any features of the decision, he has got the right to challenge it before the High Court, and after High Court before the Supreme Court. What happens next after this, we will have in the next session, inshallah. Hope you have liked the video, and if you have liked the video, do send me the comments for my so that I could prepare and I could learn from you guys. Thank you very much for watching the video.